This is In the Loop. I'm Christian Bryant. We'll have more on those stories in a few, but first, we're in a moment where state voting laws are drifting in opposite directions. In 2021, 25 states passed laws that expanded voting access, but 18 states have passed nearly 36 laws, making voting more restrictive. Both those numbers are from the pro-voter access nonprofit, the Brennan Center for Justice, which also points out that studies show those restrictions often burden voters of color. Despite these restrictions, and despite the Supreme Court weakening voter protections in recent years, one law has held steady: the Voting Rights Act, specifically Section 2 of the Voting Rights Act. But the Supreme Court is hearing arguments next week in a case from Alabama, and even that long-standing protection to voting rights is at risk of being weakened or eliminated. Section 2 has been a crucial tool for minority communities to prevent voter discrimination. It bans voting laws or practices that discriminate based on race, ethnicity, or protected language. In 2013, the Supreme Court effectively gutted Section 5 of the Voting Rights Act. That had required local election officials in areas with a history of discrimination to run their laws by the Justice Department first. Section 2 may be next. For now, Section 2 holds strong, and it's stronger than it was when it was first written. USC law professor and election law expert Fanita Tolson walks us through it.
In 1982, Congress amended Section 2 to make it easier for plaintiffs to bring these cases. So not just intent, it still reaches intent, but it also reaches effect if a law has a discriminatory impact, meaning that it disproportionately harms one group relative to another, then there's a potential Section 2 violation there.
In plain English, that means if you're suing and alleging a violation of Section 2, you don't need to show some smoking gun that proves that someone writing a voting law meant for it to discriminate. You just have to show that in practice, the law hurts a minority community a lot more than it hurts the public overall. Jacqueline De Leon has dealt with this firsthand while arguing voting rights cases for the Native American Rights Fund. The group has filed an amicus brief in the case that the Supreme Court will hear, and she points to Section 2 as a key legal tool at their disposal to fight cases of discrimination against Native American voters.
There's a lot of ways in which a map can be manipulated to dilute minority voting strength. And so Section 2 ensures that a vote is not diluted. And what we see throughout Indian country, and we've seen over this past redistricting cycle, is that there are many different ways that map makers are trying to suppress the Native vote, and we depend on Section 2 to remedy that.
Section 2 has been used to challenge things like voter ID requirements and polling place closures, but the new Supreme Court case looks at issues in redistricting. Josh Douglas, a law professor at the University of Kentucky and author of a book on the future of voting rights, tells us more.
The state of Alabama drew a map, and the state's trying to justify the map that only has one of the 7 districts as majority minority. And yet Alabama has about 20-something% of its population is Black individuals. So, the argument for the plaintiffs are, look, we are a much larger constituency of the electorate. We should control at least 2 of the 7 seats. And you could, because minorities live in a geographically compact area, you could easily draw a map that does that.
A federal court agreed. A 3-judge appeals court panel unanimously ruled that Alabama's maps did violate Section 2, but the state has appealed, and the Supreme Court issued a stay on the lower court's ruling, suggesting they may be inclined to side with Alabama. The NAACP Legal Defense Fund will argue the case before the Supreme Court next week, challenging the state's maps. Ashley Burrell, an assistant counsel with the fund, said that if the court used this case as an opportunity to majorly weaken Section 2, that she thinks the consequences could be
absolutely devastating. Section 2 is essential to ensure that minorities and minority communities have the ability to elect candidates or a fair opportunity to elect candidates of their choice. That's going to directly impact everything from healthcare to education to the roads that you drive on your way to work.
But the state is arguing in response that it didn't consider race when drawing the new map, denying that the law allows for considering race. Hans von Spakovsky is a Heritage Foundation senior legal fellow and former Bush administration Justice Department official. He thinks Alabama has the better side of this argument. He says that given the way voters split along political lines, it's easy for redistricting on political lines to be interpreted as racially motivated.
In many places, upwards of 95% of African Americans vote for the Democratic Party. It's often hard to distinguish motives that are based purely on partisanship with motives that are based on race. In other words, if a legislature, for example, wants to draw up a district that's going to pretty much guarantee that Democrats are elected, if they draw up a district in which a majority of the voters are African American, well, that just may be a coincidence. Is that racist when they do that? If their aim is politics, not race? That's sometimes difficult to distinguish.
This would be a big shift from how Section 2 has been applied in practice. Section 2 does direct map drawers to consider race to ensure equal opportunity for participation for minority voters. Although, to be fair, it does block race from being the primary factor for drawing a district. But Alabama is arguing that considering race at all makes it the primary factor. So a ruling in Alabama's favor could lead to court challenges trying to prove discrimination, having to prove that discrimination in a race-neutral way. Yeah, in order to prove racial discrimination, you wouldn't be able to consider race. It left Josh confused.
How would you, from a practical perspective, draw a new map as a plaintiff to say you could draw a map with better minority representation, but not get to think about where minorities live? It'd be a very hard thing to do. It would really make it very difficult for plaintiffs to win these kinds of cases.
And the Supreme Court may be looking at the Constitution in a way that downplays the role of race. That would be in line with how the framers looked at it when the Bill of Rights was written. But there have been times when that stopped being true, including for amendments adopted after the Civil War.
If you look at the adoption of the Reconstruction Amendments, i.e. 13th, 14th, and 15th Amendments, they were very much adopted with a particular demographic in mind, which was the formerly enslaved African Americans in this country and improving their position. And so in some ways, this commitment to a colorblind constitution is a relic of a constitution that doesn't exist anymore.
But the Supreme Court may lean toward Hahn's argument here that there should be a higher, more race-neutral threshold to prove discrimination. The court has already allowed the original maps that were ruled as discriminatory to be used until it makes its final ruling. So this court case could rewrite Section 2 to make it harder for minority communities to prove racial discrimination. Section 2 still exists in its current form for the time being, and that's netted some wins for the voting rights of communities of color. Take Lowell, Massachusetts, for example. The city has welcomed immigrants, with Europeans coming over to work in its textile industry in the 19th century. Since the 1970s, the town has seen a huge growth in its Cambodian immigrant community. It has the second largest Cambodian American population in America. And now, people of color make up roughly half of Lowell's population. That didn't translate into representation, though. The city voted for its mayor and council through an at-large system, meaning that the top vote getters citywide made it onto the council. Because of the way the city's population was split, it meant that candidates of color were largely shut out from city government. But a Section 2 lawsuit and settlement restructured the city's voting system and made some history along the way. Newsy national correspondent Ben Shamiso went to Lowell to look at how Section 2 helped communities of color get seats at the table.
I want to welcome everyone to the chamber to spend an exciting day.
He came to the US as a refugee when he was 9 years old.
May we continue the legacy of our founders.
Now he's the nation's first Cambodian American mayor, leading the city of Lowell, Massachusetts, about 30 miles north of Boston. Mayor Socorro Chow has been on the job for 9 months, well aware that he looks nothing like his predecessors.
These are portraits of prior mayors.
All of them are white guys. I mean, how does that feel? Because it's pretty obvious to me.
Hopefully, I'm the first, but not the last.
Lowell, population 115,000, is a city with deep immigration roots. It has the nation's second largest Cambodian community, and nearly 50% of its residents identify as people of color. Yet, until very recently, all of its elected officials had been white.
Please join me in the allegiance to the flag.
But that changed dramatically in January when Chow took office together with 2 other Cambodian American council members and the city's first black representative.
This is the map of the city of Lowell.
It all happened thanks to this new map.
The different color just to show the different districts, the different neighborhoods.
Used for the first time in the city's 2021 elections, these new districts changed the face of Lowell's politics. But it didn't happen without a fight.
It is very hard for people to voluntarily give up power in that way.
Civil rights attorney Oren Selstrom sued Lowell in 2017 on behalf of a group of Latino and Asian American residents. He argued that the city was violating his client's voting rights by electing every single official on a citywide basis.
There was a majority white voting bloc that was diluting the vote of communities of color, running the table in every election, not just getting 51% of the seats, but 100% of the seats 100% of the time.
After fighting in court for 2 years, Lowell agreed to divide the city into 8 new districts, 2 of them having a majority of non-white voters. Overnight, residents whose voices had been ignored for decades got multiple seats at the table.
Voting rights are precious, and when they are protected, it creates a stronger community for everyone.
In Lowell's Cambodia town, community leaders say Chow's election was decades in the making. Fleeing the genocidal Khmer Rouge regime, Cambodian refugees started arriving in Lowell in the early 1980s to find working-class jobs. Most came with war trauma, no English and no money.
I was involved with some of our older leaders back in the 90s. It was hardest to try to talk to people and try to explain to people what it means to be a citizen, what it means to participate.
Sotia Chimrum of the Cambodian Mutual Assistance Association says now it's time for other newer immigrant groups to achieve political success. Back at City Hall,
I can't really sit and also like King Charles.
It's a great looking chair, but it's not really efficient.
Chow says sometimes he still feels out of place, but he draws strength from his mother and his late father.
When my father was a captain in the army, he was one of the first to be taken to be killed. And my mother was left with 7 children. Her perseverance kept us alive during the Khmer Rouge.
What is your ultimate message to the people of Lowell, and specifically the immigrants who were not represented before?
I wasn't born here, came here with nothing, and I hope that would serve as a role model to anyone else that want to serve in other towns, cities, or states in the country.
Ben Chamiso, Newsy, Lowell, Massachusetts.